So good afternoon, everyone. This is Dr. Bashir Ahmed. I'm the president-elect for Bangladesh Medical Association North America. So thanks for joining with me. I'm your host, and we have Dr. Syed Nishat from Wall Street Alliance. He's going to be our speaker today, and we'll be discussing about state planning and asset protection. So before we go in the main part, I'm going to request everybody to mute your phone, and our speaker will talk about uh, certain topics that we already feel like are necessary for the discussion. And then there will be a Q&A session where you can ask him any relevant questions. So I'm going to ask Syed Nishat to give an introduction about him and his organization, and then we're going to go in our main program. So Syed, please.
Thank you, Dr. Ahmed, for inviting us to this webinar. We are a fiduciary financial advisor. In the wealth management, we do primarily for physicians. As a background, I am from also Bangladesh. Growing up in Dhaka, I told this story many times to this audience before that my father always wanted to be a physician. But when I came back to US and I told him that I want to be a financial advisor, he was very upset and he didn't speak to me for a long time because to him, investments or estate planning, that actually means haram. But that gives me an idea when I came to US and reach out to the first generation immigrant and speak about the importance of financial planning. And when we're reaching out to them, we find out they have unique financial planning needs. Like they have needs like state planning, college planning, asset protection. So what we have done, we have come up with a team of experts from actuaries, CPAs, attorneys who can take care of everyone's all financial planning needs in one umbrella very efficiently. So we are a fiduciary financial planner and we specialize in financial planning for physicians. So again, thank you very much for inviting me.
Thank you, Syed. So first of all, I would like to inform our audience that BMANA is a non-profit organization, and this is just for education purpose. And our attendees should consult their own financial consultant and planner for their financial decision. And as a physician, I was mentioning earlier that, we work hard and we work so hard, like a lot of time we don't find any time or pay attention, like our hard-earned money, how to protect it, both in terms of investment and also on inheritance purpose. So we are going to be discussing few topics on the estate planning as well as on our state tax and asset protection purposes, as well as we'll be talking about some basic will and trust. So before we go to that topics, as Syed mentioned that he is a fiduciary financial advisor with Wall Street Alliance. So his articles and interviews about asset protection and financial mistakes done by physicians are published in MedPage today, as well as Medscape. And he, with his partner, they are regularly being interviewed and quoted in different media outlets like Forbes, Kevin MD, US News, Investment News, and Yahoo Finance. So we're going to make it as possible audience interactive and not like long presentation. So Syed is going to get some question being asked by me and he's going to shed some light. And after each section, we will have a brief Q&A session. So having said so, I'm going to go on our first question. Can you please explain what does it mean when we speak about estate planning? What are the components and in what age a physician should be thinking about estate planning?
Yeah, thank you again, Dr. Ahmed, for inviting me. And it's a valid question. So estate planning is one of the most important but most neglected aspect of financial planning, especially I see it in our Bangladeshi community. What does state planning means? State planning means that in Bangladesh, my father always used to say, I don't need any will, I don't need any trust because the Islamic will is there in Dhaka, in Bangladesh. But in US, it doesn't work this way. Let me just give an example. I've been doing it for 17 years. One of my best clients in Texas passed away during COVID. There's no way I can imagine the suffering the family went through, but having a proper estate planning allow the family to focus on your health during this tough time. And the finances was at that time in a back burner. And I remember that when so at that time, Dr. Bashir, that the client who became sick, that was in the beginning of COVID. We didn't have this medicines like we have right now. So people used to always get into, oxygen, they need to put like, the mask in at that time. So before he becomes seriously ill, I remember vividly that he called me and said, let's take care of my family, anything happens to me. So just to give you an idea, if this client did not have a will, something as simple as the custody of the children will be decided by the US government. And Texas usually, the probate, what is probate? Probate basically means if anything happens to you and your wife, it's not like the county you live in go to the money, give you the money immediately. It goes to a process to validate the will or validate your wishes. And this term called probate. So this client would have been getting to a lengthy probate process in Texas. We were able to avoid all of it. So that's why it's very important to at least get the basic will and trust done for physician community because they're in a high risk profession. Number two question people ask all the time, at what age do I need my will and trust? Like I am 43. You might be thinking that, okay, you're young, why you need the will and trust? It's not it's a mistake. It's not the age. It depends on what kind of estate you have it. What I mean by estate, the assets you have it. Like if you have just a retirement account and if you have a house, you're single, okay, fine. Nothing is needed, maybe. But most of the time at the age of 40s people have children, they're married and they have a house, they have a retirement account. That's why as soon as your net worth is more than $1 million, we always recommend get a basic will and trust done as soon as possible. Now you ask another question, that what are the component of will and estate planning. And I just want to show my screen real quick. When we talk about estate planning, there are three major components. Number one component is a basic will. Will basically outlines what will happen to the children and your assets after husband, wife both pass away. Again, this basically a simple document. You just notarize it and keep it for yourself. Number two, there's also a part of estate planning called living will. Living will consists of health proxy. As a physician, health proxy means like, if me or my wife are in a coma or life plug in, plug out decision, that's called health proxy. Power of attorney means like my client in Texas who was seriously ill, the wife had power of attorney. She was able to actually call on the husband's behalf and make a decision for the business. Again, you need a power of attorney as well. So this is second component of the estate planning. Number one is will. Number two is living will, which is basically called health proxy and power attorney. And the last one is trust. So why trust is necessary? So what basically happens if you even have a will, as I mentioned, it's not something that your children gets the wife or your wife gets the assets the next day. They go through a probate process depending on the county you live in. Depending on the state you live in, sometimes the probate takes about 3 months, and sometimes the probate takes about 6 months. You can avoid all of it by creating a revocable trust. So that's why we also recommend creating a trust as well. So again, will is a public document, is up for probate. Trust is a private document. And in this way, you avoid the probate process. So these are the three major components. When we talk about the estate planning, it's not that expensive. You can set this up with a qualified estate planning attorney, cost about a few $1,000s. So again, get this process started as soon as possible, at least for the physician community.
Thank you, Syed. So we're going to go on the next item that you mentioned a little bit about trust. And as I understand, like, there are different kinds of trust. So revocable and irrevocable trust. We didn't learn this thing in med school. So can you tell us about what is the difference and what are unique between the two?
Yeah. So the two type of trust when we set this up to avoid probate. One is called revocable. Revoke means, as the term says, you can revoke it, change it anytime. That's what revocable means. Irrevocable means once you create the trust, you cannot change it. My question would be now, what type of trust is ideal for me? As a starting point, we always recommend go for revocable trust. Joint or single, doesn't matter, go to revocable trust so you can change it anytime. Irrevocable trust, people always only do it when you want to gift it to your children and once you're looking for asset protection. So again, irrevocable, once you gift it, you cannot actually change anything. It is out of your state. Most of the time, unless your net worth is significant, we do not recommend irrevocable trust. So again, the revocable trust is the starting point. Create a revocable trust, move the assets under the name of the revocable trust. Once your net worth is substantial, then you can think about irrevocable trust.
Thank you. Now, my next question to you, like, you said about will, you said about trust. What are the difference? Why we need to do both?
Yeah, so it's a very good question. People say if you're talking about creating a will, now you're talking about trust as well. Isn't it kind of redundant? It is not. Reason because what happened once you create a trust, you move the house under the name of the trust. You move the retirement account beneficiary under the name of the trust, but not everything can be titled under the name of the trust. Like in our Bangladeshi community, people have jewelries. Jewelries cannot be under the name of the trust. Car cannot be under the name of the trust. A lot of assets you acquire throughout your life, once you create a trust, people forget to put it under the name of the trust. So that's why you need to have a will as well. Will at that time becomes a simple document. All it says, whatever has not been put into the trust, put it into the trust, that has been missing. So that's why it's extremely important not just to have a trust, you need to have a will as well because trust cannot hold everything.
Thank you. The next item that, we want to know from you, like, say, for example, like, I created a trust, I created a will. How are we going to name it?
Yeah.
Like, how are they going to be titled?
Yeah, so a lot of people, what they do is they create a trust, but they never fund it. What I mean by funding is like if you have a house, the house should be under the name of the trust. The retirement account beneficiary should be primary, the wife secondary should be the trust. If you have a brokerage account, that should be under the name of the trust. The question is, how do I move it? You don't have to worry about moving it if you work with a, hopefully you're working with an attorney or a good certified financial advisor or fiduciary advisor. They should be able to help you title the positions, title the accounts you have it. So it's not that complicated. There's no tax ID for a revocable trust. It's just a paperwork you have to do. The house you own it, the attorney usually send it the deed of the house under the name of the trust is very simple. It's not that complicated, doesn't cost that much. So the attorney usually takes care of it. The paperwork to create the will and trust takes about a couple of months. The funding, that means moving the house, moving the retirement account, that takes about 2 to 3 months. So it is done by the professionals that you're hiring to get it done.
Thank you, Syed. So next item, like, we understand most of the time the US law are applicable to US residents. So what will happen to the non-US residents? So say like if we have someone who is not US citizen yet, how they can take the advantage of this?
Yeah, so a lot of physicians coming in J1 visa. Like I came to US as a F1 student. So in America, if like for example, now I'm a US citizen. If I pass away, my spouse, who's a US citizen, she gets everything and there's no taxes. But that's not true though for non-US citizen. There's a limit how much husband and wife, if they're not citizen, can transfer, vice versa. All right. So, but you can avoid it, all of it, by putting provisions. Speak to your attorney. You don't have to worry about that detail, but just a provision called Q dot is qualified domestic trust. It's a provision you put in. So basically, all these provisions that it says that qualified distribution from husband to wife, there's no taxes that is due. So again, it is an important thing. If you're not a green card holder, if you are not a US citizen, it is extremely important that till you're US citizen, till you're green card holder, put these provisions there into the trust. So there's no taxes due between husband and wife who are non-US citizen.
Thank you, Syed. So I'm going to ask a very sensitive question now. Like, many of us have special children, especially like, in our physician community. I have seen, you know, many children, like, who will probably not be able to manage the finances. So for those special cases, like, what kind of, asset protection or estate planning can be done?
Yeah, I think it's a very good question, and I think is one of the very sensitive topic, and a lot of physicians are not aware of it. That people who have child with special need, there's a lot of government programs available, but the government programs are not available if the child owns any assets more than $2,000 under the child's name. So, for example, if the physical therapy needs to be done, covered by the government. If the child's have any assets more than $2,000, the parents passed away, the child doesn't qualify. So this is one thing to very remember. So what's the solution for it? The solution for it, number one, one of my recently, I was talking to a physician client. They were saying, I have these assets. I want to gift it to my daughter who was physically challenged. Now, the one problem we faced it, if the child the physician has significant asset, if the daughter inherits the assets, all the government program goes away. So what's the solution? The solution is make sure nothing you gift it to the daughter more than $2,000 during lifetime or after you pass away, and you create something called special need trust. It could be either revocable or irrevocable, but most of the times we create irrevocable special need trust for the benefit of the child. And if anything happens to husband, wife, all the proceed that you want to give it to the special need trust, that is out of the state for the child. And the benefit is all the government's benefits prevails. That doesn't go away. So again, it's irrevocable. It usually have a separate tax ID, and it is not part of the estate for the daughter or the son if the child have a special need. Number three, you have to understand that there's something called SSDI, Social Security Disability Benefit, depending on what the child's situation is. Usually that's about $750 per month. A lot of physicians, they don't apply for it, but if the child, depending on the severity of a challenge, the physical challenge or mental challenge the child had, you may qualify for it. That's about $750. But think logically, Dr. Bashir, the $750 comes in, you put it under the name of the child, again, the net worth may go high, right? 750 per month can becomes more than $2,000. So, but again, you can create some sort of special need trust. The money can go as an income. Again, that money is out of the child's state, and he or she still qualifies for the special need benefit coming from the government. And lastly, a lot of physicians ask the question that can I do some sort of 529 account, like an education plan for my child who is a special need? There's something called ABLE account. It's an affordability benefit account for the child for a special need. It's similar to a 529, but up to $100,000 can be part of the ABLE account, can be used for education purpose as well. So, and although also states have their different programs, but these are the four things to remember when you have a child with special need. Number one, nothing more than $2,000 under the child's name. If you want to gift it through a special need trust. SSDI benefits, put it into the special need trust. It doesn't cost too much money, but get it done as soon as possible.
My next question to you, like, if we do the will and trust, like, how often should we, revise them? Or
Yeah,
is it necessary?
yes. So it is important that you actually revise the will and trust every 5 years. What I'm saying, Why 5 years comes into play? Because a lot of times physicians move to a different state. Like I had a client who was in Pennsylvania, moved to California. Remember, Pennsylvania statute is different. State has their own regulations different. California regulations are different. So if you move to a different state, at that time, make sure that all the statutes are you have added into the trust documents. Number two, like if the child becomes older, a lot of times, like physicians actually create a will and trust at that time when the child was minor. But now the child is not minor anymore. Why do you need like other people as a trustee? One option could be you can just make the child as a trustee of the trust. So it depending on the situation, but at least every 5 years, we recommend sit down with your financial advisor, sit down with the attorney, see your circumstances, and they can suggest if any changes needed or not.
Okay, thank you for that information. Now, the last question on the will and trust part, and this is the most important one, how much it costs to do the will and trust together?
Yeah, so a lot of people shy away, physicians, from creating will and trust because they believe it's very expensive. It's not. Just to give you an idea, a basic will that includes health proxy and power of attorney, that costs about $800 if you use like a regular attorney. I'm talking about our attorney charges almost the same. So I'm assuming most attorney who are qualified will charge the same, about $800 to $850, just the basic will, and that includes the power of attorney health proxy. Revocable trust, as I mentioned, it involves like a private documents. It's like about 30 to 40-page document. You put the trustee name, you put the beneficiary name, you outline your wishes like the way you did in will, and you have to move everything as well, like the house, and everything. So that costs a little bit of a money. So that's additional about $2,000 on top of it. So we're talking about around $3,000 to $3,500 most of the time, depending on your state, done one time. And then obviously I said every 5 years you should revisit. Small amendment doesn't cost that much, but we would say about $3,000 to $3,500 you can get the basic state planning done in US.
Thank you, Syed. So we're gonna go into our next topic about the state tax. Before we go there, as we mentioned, there will be a period, where we will invite questions from our audience. So we already have one question from Dr. Abu Yaqub from Canada. So he was asking, do you have, any suggestion on the Canadian resident or citizen, or, how the, law differ from US to them? Is your firm able to, help them in any way?
Yeah, so unfortunately, the will and trust that you create that only works in the jurisdiction of US. It's not going to work anywhere else. Unfortunately, Canada or UK, we have clients who have dual citizenship. You do have to create a will and trust there, unfortunately. But if you're here, if you have assets here, definitely we can help, but we won't be able to like actually draft it for you. Like for example, I had a client in UK. They have a system model called Barrister. So we had to call them and work with them, but that's something that you have to hire a state planning attorney there as well.
So I'm going to request our audience now, if you have any question regarding the will and trust process, you can unmute yourself and ask the question to Syed. I will request you to tell your name first. Thank you.
Assalamu alaikum.
Assalamu alaikum.
Yeah, my name is Rashid Hanif. I'm a physician.
Sure.
So when you make the will and the trust, are you able to keep the Islamic way of inheritance within, the will and the trust, or how do you work with it?
Yeah, it's a very good question. A lot of people ask this question about Sharia compliance, will and trust. So FIC Council of North America, called FCNA, have given guidance that what the distribution is going to be. For example, I'm saying the wife does not give 100% if anything happens to the husband. She gets 1/8 if you see it. So you can have the same distribution, Islamic distribution possible. Now, the one a dilemma we always face in Islamic distribution, if you see the laws, 1/3 needs to go to non-relative. Sometimes Islamic law says how to, and some people say that 1/3 is okay to give within relatives, the distribution. So the biggest challenge is basically the distribution. The rest prevail there. So you can create the same Islamic distribution if you need to in within the trust. So if anything happens to you, so what portion gives to your wife, what portion goes to your daughter? Because remember, son gets a little bit more, daughter gets a little bit of a less. All the distributions are possible. One of the challenges Islamic law has it that, as I mentioned, that 1/8 goes to wife, if you remember, and your wife is depending on you, and a lot going directly to the children. How do you fix it? How the wife will survive, right? Because you're not giving 100% like the way the laws are in US. One solution could be you can create two trusts, one trust for you, one trust for your wife, and give more assets to the wife, because only her distribution is coming from your side. So, and or you can actually give let's say house directly under the wife's name, so it doesn't become disproportionate if anything happens to you. So it is not just like the distribution Islamic said. You have to do the math with a good financial advisor who can actually give you suggestion in an event anything happens to you, your wife and daughters are taken care of.
Bashir bhai, I have a comment on this Islamic thing.
Yeah.
As I know, the 1/3, actually 1/3 is like, suppose I have $100. If I want to give that money without my orish, like orish bolte, our parents, our wife and children, মানে যারা designated in the Islam, যারা পাবে automatic, হ্যাঁ, suppose I want to give somebody, যে আমি আমার ইচ্ছে হলো আমি টাকা দিয়ে দিব, but I can give only 1/3. I cannot deprive our family or children. That is the main thing. Means they are protected. At least they can have 2/3 for themselves. So অনেক সময় অনেকে তেজ্য করে না, বা something like that. They cannot do that. Like Islamically, আমাদের দেশে অনেকে রাগ করে কিন্তু Islamically actually it is not valid. If I want to give, suppose আমি এই institution কে, suppose I want to give something in a hospital or something, যে আমার 100 টাকার আমার যে পরিত্যক্ত আমার মৃত্যুবার যা থাকবে তার একটা অংশ আমি দিব. I can give only up to 1/3, not whole thing. That is the point.
Understood. Absolutely. It's a good comment, but the important thing, all of this could be included in the will and trust. No problem.
Thank you, Dr. Muhammad Rahman, for your comment. So if we don't have any more question on the will and trust, we're going to go on our next topic on the estate tax. So first of all, like, what does it mean? Like, what is estate tax and why it is so important for us? And how it is going to help our family if we have planned it well in advance.
Yeah. So there's something in America, unfortunately, you heard the term death and taxes, right? I mean, you have to always do that. So in America, there's something called income tax. There's something called death tax. You do have to worry about it. What does death tax means? Death tax means like if husband pass away, wife gets everything free, nothing to worry about. But wife also pass away, if a net worth, meaning house, retirement account, all of it together, business and everything, more than 24 million right now, then the family has to worry about anything more than 24 million, 40% state taxes, called death taxes. You might be thinking, hey, 24 million, I don't have to worry about none of these. I get it, but that things is going down the limit in 2 more years. So remember, Trump make it 24 million, but depending on the government who comes into play, it is going down. So it's becoming only 12 million ballpark. Husband, wife both passed away. If the net worth is more than 12 million, which is changing, they have to worry about paying state taxes. So again, there's something called income tax. There's something called death tax. Right now it's more than 24 million, coming down to 12 million ballpark.
So when do you think, this state tax rule might get changed?
Yeah, so
Like,
2 more years. So this is sunsetting in 2025. So sunsetting means it's expiring in 2025. Most likely some negotiation will happen. It will be about 15 million, most likely.
Thank you. If you can, yeah. All right. So our next topic would be like, the people who are doing really good professionally successful. And if they like, hopefully make more than like, the limit that are exempted from the state tax, what choices they have, what strategies they can put forth. So to avoid like, their hard-earned money going for just taxes.
Yeah, there are a couple of solutions out there for state taxes. Number one, remember you asked the question revocable trust versus irrevocable trust. So if your net worth is more than 10 million right now, I think it's a good time to sit down with your financial advisor and CPA and discuss about gifting to the children, anything more than 10 million right now. So you can right now gift almost 22 million. Remember, after the year 2025, you cannot do it even if you want to, because the amount coming down to about 12 million. So right now you can, if your net worth is substantial, you can start gifting right now in one go via an irrevocable trust, a substantial amount of money. Number two, on top of it, every year, around close to $16,000, you can do a gifted to the children every year. Per parent is going to be 32,000. I'm saying it. And you don't have to worry about filing any gift tax. Again, it is out of your state. You can buy some sort of second to die life insurance policy that can pay for it. If you have a life insurance, remember the life insurance is part of your state if you pass away. It is income tax free, but it is again part of your net worth if you die. So if you have a huge life insurance, like I met a client whose net worth was about 10 million, but life insurance, they bought it like 10 million also. So remember, 10 plus 10, 20 million becomes net worth if you pass away. So, but if you move the life insurance to an irrevocable trust, that asset is out of your state. And lastly, like if your net worth is very substantial, a lot of our Bangladeshi people are charity minded. Like some of them ask, like you want to give them on, money to mosque or some charity, some Islamic institution. We can create advanced charitable planning where the money can go to the charity and it can zero out your taxes as well. But again, I'm not going to talk too detail about charity. It's only if your net worth is substantial. But the basic thing you can do if your net worth is substantial is start gifting it to the children, or per year 16,000 you can gift it as well. Again, it will help you somewhat to lower your state taxes.
So before you go on the next topic, because I know like you have to finish it in a certain time frame is to allow our audience to ask questions. So it's a lot of different things to digest in a very short amount of time. So I just want to let our audience know that the whole program is going to be video, and it will be sent to all of you when you have free time. You can listen to it. And if you have any supplemental questions, Syed is going to share his contact information with you, and you can always send him a question. Go ahead, Syed.
Yeah, so one thing I will discuss with you, some people asked a question, that my net worth is very significant. I want to gift it. But if I give it through irrevocable trust, like we mentioned, I lose all the control over it. Can you suggest some sort of irrevocable trust where I can have some control over it, but still I can gift it to my children? If that is your situation, if your net worth is substantial, speak to your CP or financial advisor about called SLAT, Spousal Lifetime Access Trust. But again, in your net worth, we would like to see more than 10 million only to do it. So in a SLAT, what happened, you can gift it. Let's say I have two sons. One is Ayan, Noah. I want to just gift it to them. But as long as my wife is alive, my wife can just take the money and just give it to me. So, and vice versa, I can take the money from the SLAT and give it to my wife. So that's why it's called a spousal lifetime access trust, that you can gift it, but things are in your control. The children only gets the money after you pass away. So again, if your net worth is substantial, you want to gift it, but you want to control over it, speak to your financial advisor about spousal lifetime access trust, if it makes sense or not. It's an irrevocable trust. A lot of people ask me, can you give me an example? how does the state taxes work? Can you give me an example? Let me show you one example. Let's say your net worth is 15 million right now. And every year, I am saying you inherit about 200,000, you save money, physician, 10 years, 7% growth happened, the value becomes 32 million. So according to the current law, the state taxes will be due 7 million. But if the law changes back, I'm talking about estate taxes due is almost about 12 million. Again, so if your net worth is 15 million, 200,000, you added 10 years, 7% growth happened, value becomes 32 million. Law doesn't change, 7 million state taxes due. Law changes 2025, the taxes due 12 million. Now you can fix this problem. How do I fix it? One fix option solution could be, let's say from the 15 million, you can gift 9 million to the children through the slat I spoke about. Your net worth for state tax purpose become only 6 million. The money is out of your state once you gift it. Every year, the same amount of money, you're saving 200,000, 10 years, 7% growth happen, the value becomes 14 million. Under current law, again, no state taxes due. After 2025, again, there's some state taxes due, but it's only 1.8 million. So the saving is almost 10 million state taxes. So I understand a lot of physicians may say that I'm not there, fine. But if your net worth in the range of 10 to 15 million dollar, still you are in your 50s, it is very important before the law change, speak to your financial advisor or CPA or attorney to gift money to the children.
So this is Syed's contact information. So I'm going to ask you that, what is the cost of setting up this type of trust for state access planning purpose?
Yeah, so remember at the beginning, we spoke about basic will, a basic revocable trust, and power of attorney held proxy. That's around 3,000. Now we're talking about people who are high net worth. So unfortunately, in order to preserve money, you have to spend a little bit of money. So this costs a little bit more. So we're talking about an irrevocable trust. Every trust, we name it, we use the word, costs about 3,000. So this type of slat stuff I'm talking about will cost about $3,000 to $4,000 on top of it. And then on top of it, if you need another life insurance trust, that will be another, 3,000. So we're talking about $3,000 to $5,000 to create this type of slat on top of the basic estate planning we spoke about.
Thank you. Syed, honestly speaking, we don't have many physicians in that bracket yet, but hopefully, with the help of you and, going through with your financial advice, we probably will reach there someday. So
Sure.
we are going to ask our audience if they have any questions on the state tax or relevant, items. If you have any supplemental question, please unmute yourself and ask Syed if you have anything, because we saved the most interesting part for the end. That's what we're going to discuss now, which I think more relevant to our physician. And if nobody has any question, I'm going to go on the last part, how can we actually do the asset protection? So before we do that, why it is necessary for the physician? Why, we put so much emphasis on this?
Yeah, asset protection is extremely important for physicians because they are prone to get lawsuit. There's a statistic, Dr. Bashir, was done by AMA. 60% of physicians over the age of 50 get lawsuit at least once in their life, some sort of litigation. And this statistic is quite higher for certain profession like OBGYN and surgeon. During COVID time, one of my physician in California always worried, what if a patient come and see the physician in the practice and get COVID? What do we do in this situation? So it was one of the situation that you have to be very worried about, is because a lot of people, physician clients, think that their primary house is protected. It's not true. Only Florida, Texas, and some states, primary house is unlimited protection. Let's say if your house in Pennsylvania, the assets are not protected. New York is not 100% protected. So only certain equities are protected. So it's extremely important that since physician, they're in a high risk job, to get some sort of asset protection done, it doesn't have to be that complicated, doesn't have to be that expensive, but the process must start.
So what are the strategies like, you suggest to begin with? Like,
Yeah.
and please explain this in a way like, we can connect with it, so we can understand it better,
Yeah.
maybe with some examples.
Right. So the easiest solution is, a lot of times I see that physician get lawsuit under their name. Like, I'm just giving example, pulling on you, Dr. Bashir. You are a physician. Most likely the asset will come, someone will sue under your malpractice. So the malpractice, anything, it covers it, but anything more than that, it can go higher. I'm just giving example. But your spouse, I'm saying if it's a non-physician, the simple solution, as long as you trust your wife, give the wife more assets. Like the house, if you live in New York, don't have it under your name, have the spouse who are non-physician under that spouse's name. If you have any businesses, have the businesses not under your name, under the name of an LLC, because LLC is a separate entity. I mean, I see a lot of mistakes people make, that they own real estate. Like a lot of physician Bengali in New York, they do it, but they're all under their own name. Now, if a tenant sue you in one building, one unit, everything under your name is exposed. Simple terminology. So the best solution is that every real estate you own it, have it under the name of a separate LLC. But you might be thinking that every LLC costs money. Yes, it's not that expensive. But okay, so at one point, should I open LLC for each property? If the property is more than $250,000, just have separate LLC for that property, and have the property not owned by you, by the LLC. If a tenant sue you, only the property under the name of the LLCs are exposed. The rest of the properties are completely off. And then also on top of it, the owner of the LLC will not be you, it will be your wife or the spouse who's non-physician. This is a simple solution. Number two, a little bit complicated solution is statute. Number one, I am hovering my mouse, joint tenants in entirety. It's a type of statute. Every states have it, that if you get a lawsuit and if the assets are owned by this title, the assets are protected. For example, Florida, where you live in, there's something called joint tenants in entirety. It is also there in Maryland. It's also there in Virginia, also here in New Jersey. So each state have this statute depending on the state you live in. If you own it under this joint tenants in entirety, the assets are again protected. Number three, family limited partnership. So again, this is, I'm only talking about once you're done 1, 2, 3. Once you're done with it, is still, if you need additional asset protection, speak to your CPA about family limited partnership. Family limited partnership have elements of asset protection, 401k, cash balance, IRA, annuities, they have elements of asset protection. So don't have to worry about too much asset protection there. On top of it, make sure you have enough umbrella policy. A lot of physicians don't have umbrella policy. This is for the real estate you own it. The umbrella policy, at least try to go for $2 million. It's not that expensive. The company that you do your home mortgage, like State Farm, Geico, they all have umbrella policy. Just call them, $2 million policy, get it. After even doing this, if you have big assets, net worth I'm talking about, you can create asset protection trust. Remember, irrevocable trusts have elements of asset protection as well. So the first solution is go for low hanging fruits. What are the low hanging fruits? Low hanging fruits are, number one, if your spouse is non-physician, give it to her or him more, as long as both of you have a good understanding. Because the problem is, if a divorce happens, that spouse gets more, right? So that's number one. Number two, real estate, own it under LLC, not under your name. Number three, look for statutes, joint tenants in entirety. If you look into the state, own it by that particular title if you need it. Put more money into 401k, defined benefit, IRA, because they have asset protection. Get the umbrella policy. These are called low hanging fruits. After you're done with this, still if you need additional asset protection, you can create FLP, asset protection trust, and irrevocable trust I spoke about. I hope kind of clarifies a little bit as a starting point.
So definitely, like, this is sort of like, the most uh, easy to understand part, so far to me. I don't know about my audience, but you are very precise and very clear about this message, that where to start, what to protect first, and then what should come next. So, we like to know about this thing more, and then, we will be doing some supplemental webinar on this matter. So you have mentioned to me, like, that there is something called Nevada Asset Protection Trust. I mean, how it is relevant to us and how it can help. Is people only live in Nevada, they can use it, or anybody can use it?
Yeah, I just want to point out there, a lot of time, like all these webinars we go for BMANA, they said, hey, I heard about Delaware Trust. I heard about Nevada Trust. Can you just tell me what is this all about? Again, remember, just going back to the slide, asset protection trust, only after you're done with all the basics, if your net worth is substantial, and like, for example, I had a client who's a cardiologist, and always they live in a state where it was like lawsuit prone. And they said, I want to protect my assets, and if I get a lawsuit, what to do? You can, if your net worth, again, substantial, I'm talking about, you have done everything, still if you need asset protection trust, it's called Nevada or Delaware, something similar always. So Nevada Asset Protection Trust is the statute of Nevada. You don't have to be a resident of Nevada to do it. You can be in New York or any other state and create this trust. It is just called Nevada Asset Protection Trust. Nevada have statutes. Once you put the money into this trust, after 3 years, it give you asset protection, even divorce protection too. So again, depending on your situation, your income, it is expensive. It costs about $5,000 to set this up, and you need to have a Nevada trustee. Like our company, we have Premier Trust, who are Nevada trustee to manage it as well. So not only 5,000 you do to set it up, every year it's about $2,500 to maintain it as well. So this is the same logic for Delaware as well. I'm talking about ballpark. So again, if your net worth is substantial, you must have heard about Nevada Trust or Delaware Trust. If you're a very, very high risk profession, want to protect your assets like the house and everything, after you have done all of this, think about it if you want to.
Thank you, Syed. I hope, like, we don't need to go that far, because,
Yes.
yeah, I want to ask you, like, our audience, before, I go to you, the final question, like, if anybody has any questions regarding the asset protection, will, trust, all this matter. And my question to you, Syed, like, I know that you have given us all the information. Our average attention span is probably 10 to 12 minutes. So anything you said after 12 minutes is probably went above our head.
Yeah.
So how our audience, our members of our organization can get the help from you, and how your firm or, your organization can do some partnership with our members. So can you please shed some light on that?
Yeah. So one of the things what I see, a lot of times a physician thinks that financial advisor means like buying life insurance or buying some mutual funds and stock all the time. It's not true. If you're looking for a true fiduciary financial advisor, usually a financial advisor take a look at your overall scenario. Like today we're talking about estate planning, but another things what we do tax planning a lot. We do disability, life insurance, and everything. So you don't have to worry about going to 10 different areas. If the financial advisor is true fiduciary, usually when you choose a financial advisor, number one question to ask that do they have the team of experts, everything in-house. So you don't have to go for life insurance, one guy, asset protection, another guy. Because typically what happened at Bashir, that if you go to life insurance guy, all they sell is life insurance. Everything you investment life insurance. So that's the solution. So that's why it is not, it's a conflict of interest. But if you go to like a true fiduciary advisor who has a CFP, who has a CFA in-house, who attorney in-house, they work as a fiduciary like the way, Dr. Ahmed, you are a fiduciary. Like your internal medicine, a patient comes to you, you take a look at the big picture, then you suggest what's the best course of action. And then the physician go from there. So there's no conflict of interest here. So that's what we're here to do, make sure we work as a fiduciary. So don't give you any conflicting advice, tell you what is right for you. And financial advisor could be complicated, but it doesn't mean that you have to listen to everything. We are the one who can dissect it for you, what is important for you, and can give you a roadmap that can prepare for you in your overall financial plan in a more stable way.
So I would like to thank my audiences, thanks for your patience that, you listened to this for last 45 to 50 minutes. So before we go, I want to ask the members, like, if you have any question to ask Syed, I think he will be willing to answer any question you might have at this point.
I have one question, Dr. Bashir. This is Dr. Mahmood Rahman. My question is as he mentioned that as an internist, we guide our patient to get the right choice. Yes, we have a fee, and we charge the fee for taking care this patient as they are our patient. So how much is your fee? Suppose you give you have my information, all the information, whatever I give it to you, and you give some kind of prescription. How much is the charge for that?
Yeah, for
I would
BMANA.
like to answer
Yeah.
that, Syed.
Yeah.
I would like to answer that first, because not many of us are his client, but few of us already joined his firm. So the first initial advice with this organization is completely free. So they are not going to charge you anything. They will give you the advice, which is completely free. And then if you do decide to go with them with certain products that they support or they can help, then they will have some fee structure for that. So Syed, you can answer if you want to add anything to it.
Yeah, so our main intention, because what happened, Dr. Mahmood, you asked this important question. So how much is the charge? So our main objective is to increase the awareness of the importance of financial planning within the Bangladeshi community. So what we are doing, that if you need any help, you just feel free to call. We will just give you advice for free. So this is okay, the roadmap and everything. Once you decide to be our clients, most firm, because we do so many things in one umbrella, they have a minimum investment requirement, which is about 500,000 to be our client. So our custodian is a company called NFS, National Financial, which is part of Fidelity. We open the account there, we manage it. Going forward, I'm saying it, and we charge a fee. A typical fee starts with 1% per year to manage the assets with our custodian Fidelity. That management fee includes all the consultation going forward. There's no dollar fee you have to pay. Once you invest $500,000 with us, we take care of everything under one umbrella very efficiently with our client. But as of right now, as I said, Dr. Ahmed called us, a few years ago, and I said that within our community, I want to increase the awareness. So whoever is calling us, you can ask anyone. We're not charging them anything, telling them, okay, we listen to you. These are the things to start first. You get started. Even if you don't have $500,000, you can get the process started by yourself. Once you have 500,000, you can come to us and be our client.
Thank you.
Thank you.
Anybody else have any other questions?
Hi, good afternoon. I have a question. This is Sakif Hassan from New York. So in New York, there is a law. It's called tenancy by the entirety. That means that if both spouse own the house, if there's a lawsuit happen, the primary house is protected because another spouse is also living in the same house. Is it true?
Yeah. So New York, if you see my slide, first thing I said, joint tenancy in entirety. New York wasn't there. They just adopted it. So yes, primary house, as long as it's joint tenants in entirety, the assets are protected. So the only problem becomes if the wife pass away, then if you get a lawsuit, it's not protected. But what are the chances of that happen? But that's why I think it's a very important joint tenancy of entirety. Get it done ASAP.
Thank you.
Any question? So Syed, we did good. Like, we finished the whole webinar within our, 1 hour time frame. So we still have 1 minute left. So if you have any closing comments.
No, but
for
thank you
our
very much, Dr. Ahmed, for what you're doing for your community. Really appreciate it. It's a completely thankless job, but thank you from my side. And then the recording will be there available. We'll sending it to everyone. If you need anyone, any question, feel free to call our team. Someone will be able to answer you, but I'm looking forward to seeing everyone in California.
Yeah, for our audiences, like, who are coming for the California convention, Syed is going to be there for the whole time. And he's, one of our, large sponsor for our event. So, we're looking forward to have a long partnership with Wall Street Alliance and a team of Syed Nishat. So thank you again for your time. Thanks to our audience, all the members, have a nice weekend. And I wish all of you good health and also, successful in your wealth.
Thank you. Thank you,
Thank you.
Dr. Ahmed, for inviting again. Thank you very much. Thank you, everyone.